Hi, I'm Sue Miller with the Wisconsin Automobile and Truck Dealers Association. In this video, I'll be addressing a common dealer question. My customer is asking if they can buy the car but not be on the title. Or my customer wants to be on the title but not on the loan. So to answer that, we need to look at the legal documents that control a financed vehicle transaction. There are three primary documents involved in a vehicle sale with a loan. Each document does much more than what we'll discuss here, but for purposes of answering the whose name goes where question, this framework should help. First, the purchase contract. The purchase contract documents the terms of the sale between the purchaser or purchasers and the dealership. Second, the loan agreement. The loan agreement documents the terms of the financing and grants a security interest in the vehicle to the lender. Third, the title application. The title application assigns ownership and files the lien. So let's talk about how the names align. While there isn't a specific statutory citation in Wisconsin law that directly addresses this question, Wisconsin DMV has stated that logically, the definition of being a purchaser means that that person becomes an owner. Because of that, the names on the purchase contract and the title application must match. Now, what about the loan agreement? There's no specific legal requirement that the names on the loan agreement match the purchase contract or title application. However, lending institutions typically require the names to match. Why? Because the loan agreement creates a security interest in the vehicle, and only someone with ownership rights can grant that interest to a lender. Separate from that security interest is how Wisconsin handles the title. Wisconsin is a title to lien holder state. When there is a loan, the lien holder controls the title. The title application assigns ownership and records the lender's lien. This structure becomes relevant if ownership changes are requested after the sale. So, what if someone must be on the loan but does not want to remain on the title? A best practice would be for the customer to work directly with the lending institution to obtain the title and request approval to change ownership. Because the lien holder controls the title, the lien holder's cooperation is required. Now, there are some lenders that may allow an individual to be listed on the loan agreement without being listed on the purchase contract. In those cases, the lender is responsible for ensuring it has a valid security interest. Dealers may be able to place financing with a lender that permits this structure. That said, those lenders are the exception rather than the rule. Standard practice is for the same individuals to be listed on all three documents: the purchase contract, the loan agreement, and the title application. Keeping the names consistent across all documents helps ensure proper ownership, proper lien filing, and fewer complications after the sale. Thank you for watching. If you have questions or ideas for a future short video topic, please feel free to contact me at 608-251-8024 or by email at smiller@watda.org.